very good evening to you and welcome to today's edition of Politics 101. This evening we'll be dealing with the situation at Gecom. If you remember last week, the Gecom commissioners, the PPP's commissioners at Gecom tabled a motion to dismiss the chief elections officer, the deputy chief elections officer, and the Region 4 elections official, Mr. Clement Mingo. And then this week, we heard that new charges would be brought against those three persons. And yesterday, those charges were brought. According to the reports in the newspapers, the charges were read in the absence of the three defendants, and the case is put down, I think, to the 29th. We're going to try to make sense of all of that this evening. We have a panel that includes the attorney for the three accused, Mr. Nigel Hughes. We have Mr. Aubrey Norton, who is the executive secretary in the office of the leader of the opposition, himself a political scientist, and Mr. Vincent Alexander, who is a Gecom commissioner for the representing the interest of the opposition parties. Gentlemen, welcome to Politics 101.
Thank you very much. Good evening.
Good evening. Nigel, let's start with you. These are new charges. What is the position with the old charges? Are those charges dropped? Are these new charges in addition to the old charges? Please, if you will, bring us up to speed with what happened there. Volume, we're not hearing you.
You hearing me?
Yes, I'm hearing you now.
Sorry about that. Yeah, I wonder if I could correct a misconception in today's press in relation to the contention that Mr. Loingfield, Ms. Myers, and Mr. Mingo did not turn up to court. I just think it is important, not that it affects the question that you asked, but I think the pattern of conduct by the Guyana Police Force needs to be highlighted. On Tuesday this week, Mr. Caesar contacted me and asked me to bring Mr. Loingfield and Ms. Myers to Ivleri at 3:30. We arrived there at 3:20. Mr. Loingfield went in first. There was a video recorded interview with him in which they said that they intend to file 2 charges against him: conspiracy to defraud the electorate of Guyana in the national and regional elections. Immediately as that interview ended, it was a very short interview, I inquired when they would have to go to court, and Mr. Caesar's response was, they have not yet filed a charge, we will get back in contact with you. After his interview was finished, exactly the same process took place for Ms. Myers, and at the end of that, same question, same response, and he said he wanted to see Mr. Mingo the following day. I said, fine, 8:15 a.m. in the morning, Mr. Mingo will travel from Belladrum, which he did. We got there at 8 o'clock. At about 8:25, they did the same process, interviewed Mr. Mingo, told him he's going to be charged with conspiracy to defraud the electorate and that he conspired with Mr. Loingfield, Ms. Myers, Ms. Valda Lawrence, Ms. Carol Joseph, and some of the other persons who had been previously charged. Again, I inquired, when do they have to go to court? And they specifically said, they haven't filed the charges yet. We'll get back in contact with you. At 10:52 a.m., I got a call from Mr. Caesar saying, we filed the charges, you have to go to court at 11, which is in 8 minutes. I said to him, absolutely impossible. Mr. Mingo has already started his return trip to Belladrum, and in the traffic in Georgetown, I doubt whether either Miss Myers or Mr. Lowenfield will get here. I got in contact with Mr. Mingo. He said he would turn around. Mr. Caesar called me back at 11 o'clock and said, in that case, come at 12. When we arrived at the court at 11:45, the charges had already been read behind the backs of these persons. The magistrate adjourned the matter to the 29th and asked that summonses be issued to these persons to notify them of the court date. I indicated to the police prosecutor, who said that Mr. Ramdani is the special prosecutor who will be joining the case, that we were only notified 8 minutes before, and it was impossible for either Mr. Mingo to turn around from halfway up the East Coast, or for either Mr. Lowenfield or Miss Myers to have gotten there for 11, since we only got the notification at 8 minutes to 11. So there was no situation where they failed to turn up, having got the notice at 8 minutes before 11. To come to your specific question, these are new charges in addition to the old charges. You will remember this started in August last year with private criminal charges that were brought by a series of persons, including Mr. Ramson, who brought a private criminal charge against Mr. Mingo. The Director of Public Prosecutions then reviewed the file. She then instituted charges on behalf of the state, and those private charges were then withdrawn. And several other persons were also charged: Miss Lawrence, Miss Joseph, and Miss February, and a series of people. So these are new charges that have been filed. One of the important things that I think the audience needs to know is that the Chief Elections Officer and the Deputy Chief Elections Officer, they receive SOPs. They don't have anything to do with the SOPs, and they certainly cannot direct the returning officer how to compile the SOPs, which is a big misconception that is being bandied around in several media. The chief and the deputy have no power, and Vincent is the expert here, and I bow to his and Aubrey. I bow to their superior knowledge in this, but the responsibility of both the chief elections officer and the deputy is really there just to support the chief, is to receive those SOPs. They cannot interfere with the process of the compilation of them. But the short answer to your question is that these are new charges that are in addition to the old ones.
Nigel, what do you think as per these new charges? Is there any connection with the handing over of the SOPs to the police as ordered by the court?
Well, that was another unusual order. The SOPs, I'm assuming, and this is purely for PR purposes, I'm assuming that the police are going to claim now that they have received the SOPs or copies of the SOPs, and consequently they have reviewed these and have received advice to institute these charges. The SOPs can't disclose a conspiracy, which is what the charges say. They're saying that Mr. Lowenfield and Miss Myers conspired with these other persons, including Mr. Mingo and Miss Lawrence and Miss Joseph and others.
If you can, for the audience, explain in layman terms what the charges mean. What are they accusing these people of?
What they're saying is, look, Mr. Keith Lowenfield, Miss Roxanne Myers got together with Mr. Mingo, Miss Valda Lawrence, and Miss Carol Joseph and some other people, and attempted to, new charge, defraud the electorate of Guyana. Don't know what that means, but that is the contention, that the electorate of Guyana was defrauded as a result of acts of conspiracy, which would be an agreement between these persons to conduct a criminal enterprise or a criminal act.
Vincent, let me bring you in here, because you have been making a very important point, and that is that there are procedures in Gecom, which includes that when a declaration is made, it has to go to the commissioners, and the commissioners have to check it. uh, you have claimed that that process did not occur. If you can expand on what Nigel just explained, and using your explanation that this process was not undertaken, what are they really getting at?
Thank you very much. First of all, let me start where Nigel made the point about the involvement of these officers in the compilation of SOPs. In Gecom, for the purpose of elections, officers have statutory authority. In other words, the authority is specified in law as to what they are supposed to do. In that regard, the returning officer has statutory authority. The law specifies what the returning officer is supposed to do. In the electoral system, there are 10 returning officers. And those 10 returning officers, under law, have an obligation to do the compilation of the SOPs in the electoral district. And on the basis of that compilation, to produce a report which is then sent to the chief elections officer. So the fact of the matter is that these 10 reports are compiled even physically away from the center. They're compiled in the 10 districts. That means in Region 1, there's a compilation in Region 2, right through to Region 10. I think the first thing that people seem not to understand is that it's just a matter of physical convenience that Region 4's returning officer was physically located in the same building as the chief elections officer. But he was not under the jurisdiction of the chief elections officer insofar as he was conducting the affairs of District 4. And he has the statutory authority to conduct those affairs and then to send the report on to the chief elections officer, who then does a compilation of the 10 districts, and that is brought to the chairperson, who presents it to the commission, and on the commission's fiat, the CEO then does a declaration, but it's after the fiat of the commission. So I think that's the very first point that one needs to make on this matter, that these are separate officers, separate functions, and the CEO does not get involved in the operation of the district. That officer does his job in keeping with the provisions of the law. The second point I want to make is that the deputy CEO also has statutory functions. And those statutory functions are related to things other than the issues at stake here. That is the compilation of SOPs, the declaration of results. The DCU has absolutely no statutory, obligatory responsibility for those things. The DCU is more involved in the discipline services, the conduct of discipline services elections, and some aspects of registration, and may administratively lend assistance to the CU in the conduct of his duties in his office. That's if he details her those responsibilities. So again, one cannot, as a matter of course, associate the DCU with the matters which are being mentioned in this so-called conspiracy. If that is the case, then certainly the CEO and the DCU cannot be a co-conspirator with Mr. Mingo. because he has a standalone operation which allows him to produce a result to those people. Coming to your point, there's a very interesting thing happening here. And I want to go back to the history of our elections and these duplicitous people who are involved. In 2011, when Mr. Boudou brought to Gecom a false result, which may be referred to as attempted fraud. The commission discerned the falseness of his result and intervened for the result to be corrected and for a correct result to be declared. That occurred in 2011. Boudou was not charged. Though, as I'm saying, what occurred should be categorized as attempted fraud. He was not charged. If people are keen enough to check the records and the pronouncements of the People's Progressive Party at that time, their contention was, well, there was a problem, but the system worked.
There you go.
Because in the course of things, whatever went awry was brought back on the right stream and the results were announced. I think that's important to note. Because in the case of 2020, that system was not given the opportunity to work. And one of the reasons why the system was not, and in fact the main reason why the system was not given the opportunity to work, is that the process which provided for the Gecom commissioners to be recipients, and this is the chairperson and the 6 commissioners, to be recipients of statements of polls and to verify the authenticity of those documents. And on that basis, to be able to have in their possession the actual results, that process was derailed. Region 4 was conducting its business coincidentally in the same building. There seemed to be issues occurring there, protestation and things like that. And 3 of the commissioners abandoned their obligation to be recipients of those statements of polls and started to be involved in what was happening in Region 4. And I'm not going to contest whether they have a right to be involved or not. But I'm certainly saying that in normal circumstances, in 10 districts, commissioners don't go around 10 districts getting involved with what's happening in those districts. It's physically impossible. It's not statutory. It's not intended. Commissioners stay put at the center to do what they have to do. But in this instance, they abandoned the process we were involved in and therefore deprived themselves, whether intentionally or otherwise, of the opportunity of being the recipients of the totality of the results. And in so doing, we, as a commission, were in no position to receive those 10 declarations, whatever they might have been, fraudulent or otherwise, and to use our information, which is valid, authentic, legitimate information, to say that those are not the results, and those reports are false. And on that basis, I have those reports corrected. And as they were corrected in 2011, then announced. We deprived ourselves of that opportunity because we derailed our own process. And at the end of the day, we're not recipients of all of the statements of hope. And it's quite interesting to know that that process of derailing coincided specifically with what was in Region 4 at a particular point in time. And therefore, the statements we did not have, because we did not dispose ourselves to having them, are the statements which are at the center of the controversy. So we did not allow the system to work. But that might not be a true statement insofar as whatever else happened thereafter constitutes aspects of the system, though there were aspects that had to be engaged because the system, the original system, did not work. So whether one claims that under the recount, we use the provisions of the Constitution of the People's Representative, the People's Act, for the purposes of overcoming a difficulty, all of that is a part of the system. And so whatever we got to in terms of the recount involves the system, and there is a result and a government in place, and so one may use the same argument that the system worked. Suffice to say that in my view, my humble view, the extent to which the Guyana Police Force, more specifically the Commissioner of Police, having received information from the Chief Immigration Officer, authenticated the fact that the ballots being counted during the recount included ballots of persons who were not in the country at the time. And in a similar manner, the Registrar's Office provided information to authenticate the fact that persons who had been deceased were also ticked off as having voted. And therefore, we had information prior to that final declaration that there were fraudulent votes being counted. And in my humble opinion, notwithstanding the argument that some things are for petition, I could hardly accept that if you are in a position to determine prior to declaration that there are fraudulent votes, that one could simply say, well, leave that for a petition. So in that regard, the system probably did not work. But given the people who say the system worked, what occurred eventually is equivalent to the system working. And when the system worked in Boudou's case, that was the end of the matter. Here, the system, by analogy, worked. It is not at the end of the matter. People are being dragged before the court for all sorts of reasons. When we have repeated instances in our electoral system of acts that are a breach of the law, known persons conducting those acts, but once the system worked, then that was the end of it. In 2011, the Guyana Elections Commission instructed the Chief Elections Officer not to issue certificates of employment to party reps who are going to be working in polling stations, other than polling stations in the places where they were entitled to vote. We instructed Boudou not to do that. He advised us he had not done that. and would not do it unless instructed. I discovered on election day that certificates of employment were issued to polling officials of the People's Progressive Party at the Alexander Village Nursery School. I discovered that. On further investigation, I was advised by Mr. Norton, who's on this program, that similar occurrences took place in District 10, Region 10, which meant that APNU representatives who were working in polling stations other than the stations located in the districts or the polling divisions where they were entitled to vote could not vote, or if they wished to vote, they had to leave the polling station unattended to go somewhere else. And so, for all intents and purposes, they were faced with the predicament of either being disenfranchised or not being able to scrutinize the process where they were working. That occurred. Mr. Boudou was not charged. And I dare say in that instance, the system did not work because they were disenfranchised or they were deprived of the opportunity to carry out their regular functions. So that one can only conclude that there is something afoot at this time, other than allowing the system to work to get a result which determines the result, which determines what the voters would have said at the polls. Something else is afoot. And the persons who are pointing their fingers have absolutely no moral ground for what they are seeking to do. And they have been duplicitous in terms of legal grounds for seeking what they're seeking to do, having themselves turned a blind eye to the illegal acts that occurred at previous elections. And I may dare say that may have occurred at the 2020 election as well. I would like to pose a question, however, to Attorney at Law Nigel Hughes for clarification. These charges started out as private criminal charges. The charges were then taken over by the Director of Public Prosecution. Today we have new charges, and I would wish to be advised. Who are the complainants? Who are the persons who have gone to the authorities, to the police, to say, here is a matter that I would wish to have investigated? Bearing in mind that the previous charges were taken over by the Director of Public Prosecution. I don't know that separate and apart from those charges being taken over, that there are people, these electorates whose votes were being conspicuously not counted, or whatever the case might be, approached the police and said, here is a complaint, could you investigate and take legal action? I would like Nigel to help me to understand what has indeed occurred, within that framework that I've just explained.
You need to unmute your mic, Dr. Hanks. Your mic is not muted. Unmute it, please.
Yes. Is is um is Mr. Hughes? No. Is Aubrey there?
I am here.
Nigel, did you hear Vincent's question?
I certainly did. And
Yes.
a very brief response. One, the Director of Public Prosecutions took over those private charges. She discontinued the private charges and then instituted new charges. To Vincent's specific question, nowhere in any of the interviews with any of the persons who, quote unquote, you would call suspects, was there any indication that they were in receipt of a complaint. And insofar as the charges in court are concerned, they would only be what we call the complainant as opposed to the. What Vincent is asking is, who is the virtual complainant, meaning the real complainant who has made this allegation? And that is not disclosed either on the charge, because it's a police officer who filed it, so he's just a complainant as opposed to the virtual complainant. And the particulars of the charge do not disclose the identity of the virtual complainants or whether there was actually a complaint made by a specific person. Vincent, I don't know if that addresses your question.
Does answer my question, but it begs the question, is that the way in which matters are brought before the court?
No, of course not. You have to have a virtual complainant. Somebody has to be the victim who has to go and make a complaint to the police. So to pick an obvious example, if somebody is assaulted, the victim of the assault goes to the police station and says, look, I was assaulted by Mary Jane or whatever. And that's the virtual complainant. The person who actually files the charge may be a police officer, PC Williams, but the virtual complainant is the person who goes and makes the complaint. That is not clear here at all. With the private criminal charges, you had who the virtual complainant was because that was also the complainant. But the DPP withdrew those charges and instituted new charges. And certainly in relation to these charges that were filed yesterday, there's no indication either in the interviews. As a matter of fact, there was no question at all put to any of the persons about anything that they are alleged to have done. So if you have a suspect who they say, look, on such and such a day, you called Mr. Mingo and you instructed him to do X, Y, and Z, then do you have anything to say to that? That is called part of what you would call an investigation. But in this case, they were just simply called in to be notified that charges had already been prepared and that they were going to be filed the following day.
Aubrey, long wait, but you've heard from both Vincent and Nigel. You can jump in. You have to unmute.
Going back to mute. I'm muted.
All right, we're hearing you.
You hear me now?
Yeah.
I've listened to the Learned Counsel, my friend Vincent. I appreciate a desire for law and logic, but I wish to place on record that the people we are dealing with have no interest in law nor logic. You're dealing, in my opinion, with what I consider to be a barefaced political cabal. And when you're dealing with people as corrupt as the People's Progressive Party, it's stretching it a little far to believe they have an interest in law. Vincent himself has outlined that historically, and if you go back to as far as the 1961 by election, it will be established that the People's Progressive Party never had an interest in law, will never have an interest in law, but in political expediency. And so I believe that in law, there is no case. I will also have to look at why are they going outside of the law to do the things they are doing. I argued before that this is a case of the PPP telling you what you pick for before you tell them what they want. I've argued before that the People's Progressive Party, their actions here are aimed at hiding the fact that the recount revealed that the People's Progressive Party was involved in wide-scale electoral corruption, and the laws and that the votes that would have placed them in government are clearly fraudulent votes. When one look at the process, one would recognize that even in this process that they were calling fraudulent, there was no declaration. So I don't know how, if I didn't declare this happened or that happened and give some result, you would be able to say I was involved in fraud. It's like saying you're charging me for thieving a book, but I never got the book was never there. In my opinion, this is pure politics. Now, the first task of the People's Progressive Party is to ensure they are never brought to books for being involved in electoral fraud. The People's Progressive Party believes in their PR machinery. And so they intend to use their PR machinery to point fingers at others so that the illegalities they were involved in will never come to the fore. And this is so because the People's Progressive Party and sections of the international community had decided long before that they wanted the People's Progressive Party in government. Let us recall it was at the time of Trump and Trumpism. And I'm characterizing Trumpism here as a political process in which I want you to believe what I say, even if the facts are different. And that has been a hallmark of the Trumpian era. So there was no interest really in having proper results. The interest at the time was to satisfy the requests made by the PPP through the millions they spent on Mercury to get them back in power. In that process, some persons in the international community became compromised. It was followed by a recount which they demanded be live streamed. So the Guyanese people saw exactly what happened. Let us recall that the chairman of the commission said publicly, I'm not going to count these boxes. And whatever happened behind the scenes, those boxes that she established, that the transparent process established, that did not have the requisite documents to make those votes legitimate, she legitimized them by just saying, we'll count them. You had a 4-stage process. This is what was agreed to in the recount. And then, as the US and company put pressure, and the PPP ensuring that they got benefit for the money that they paid Mercury, it was decided that we wouldn't go through the entire process. Because remember, in the process, you were going to recount. There was an observation sheet where all the observations were made about the irregularities. And to go in that direction would have meant to uncover the reality. And as a consequence, you would have not been able to declare the PPP a winner. So what they did was they decided they wouldn't go down that road. They will arbitrarily say you have to use the results of the recount and forget the observation made. And so what one has to recognize is that there was no intention to operate legally. The intention was to install the People's Progressive Party regardless of what occurred in the elections. And I believe there is where we have to focus. You look at the treatment of petitions, you will see there is no attempt to hear petitions. Whatever has been planned is to ensure that at the end of the day, the PPP is in government and the law doesn't matter. Now, I come to what is happening now. What is happening now, in my opinion, is a consequence of a number of activities. First, you came into government, you remove from the police force all the persons you believe you cannot control. And then you have policemen, many of them compromised, involved in illegalities, had complaints against them. They have a history that is questionable, and you place them there. And then the police force does something that is unheard of. In all my life, I never heard you charge people, then investigate. That is what is happening before us. Now, you are bringing these charges after you would have brought charges without any evidence. I don't think they have any evidence now, but they are purporting to charge based on what is on the statement of all. But again, that doesn't make sense. While I'm no lawyer, I did a good bit of law courses, and I'm interested to see how they will prove conspiracy. Because the only conspiracy here appears to me, the PPP conspiring with the police to first persecute and then prosecute people. I don't know in a proper court of law that will succeed. It is like saying, I charge you for the murder X, and then I go and find evidence for the charge. I mean, Ghana is a special place. I have a friend that described it as Google, where anything happens. It doesn't have to make logical sense. Which decent person will accept that you charge people, then go looking for the evidence? And that is what we have here. So while the legal battles have got to be fought, the reality is, I said it before, this has to be a political battle. This is no issue in law. This is an issue of the People's Progressive Party seeking dominance. They are seeking to get rid of everybody from Gecom that they perceive they can't control. They want to have a voodoo-like situation where the person is clearly in violation of the law, but they will be directed by the political directorate and do exactly what the political directorate wants, whether it is legal or not. And so we must be clear, yes, council and company have got to do the legal work. We believe that the charges are frivolous, but if they are left like that, nothing is stopping them from prosecuting people without evidence. And if you accept that there are magistrates that are compromised, that is why I like the fight for the matter to go in a different direction rather than in the hands of one magistrate. Because people are facing political persecution. That is what it is. It is an attempt to persecute, then prosecute. And therefore, only response to political persecution and to prevent prosecution is political action that stops the PPP in the track. And then let us be clear, you're not dealing with people who have some morals. A man could have had 19 fraud charges and operate like if he's a priest. What that indicates is that they have the capacity to do wrong and suffer no compunction, not even a slight pricking of the conscience. And so we have got to understand all of these things and put it in context. We are involved in a battle with an installed regime that sets out to persecute, then prosecute, and to shift away from the limelight the fact that in virtually all of their constituencies there were illegalities. There was a woman in the quarantine who Gecom ended up moving, I recall, who was involved allegedly in illegalities. Nandalal himself, it is alleged, was caught with ID cards distributed, but the focus is not on the illegalities in the elections. The focus is creating a perception that these are the people to be persecuted and prosecuted and to go down that road. I believe that there is no interest in law. There is no interest in democracy. This is pure political pandering with the aim of driving fear into Guyanese generally, but more particularly the APNU, AFC supporters, driving fear into the Guyana police force, driving fear into all Guyanese, so they do not want to challenge the illegalities and irregularities that occur under this installed illegitimate regime. That is my position.
Aubrey Norton, Executive Secretary in the Office of the Leader of the Opposition and leading member of the People's National Congress. Nigel Hughes, let me get you back in here. Is there a precedence for these cases in Guyana or in the wider Commonwealth Caribbean?
Precedent for, you mean conspiracy to?
Yes, these kinds of charges. Have there been instances in the past, in our post-colonial era, in Guyana and the wider Commonwealth Caribbean?
Not in relation to the charges in the manner in which these have been framed.
Mm-hmm.
Certainly not accusing the head of the, the chief executive officer or the chief elections officer of attempting to defraud the electorate. They're more specific charges that are based on a specific statute, a specific section of a particular electoral law or a criminal offense. I have not come across any.
Yeah, I've been trying to do some research to see, and I haven't come across any myself. Now, I'm interested in this thing about defrauding. Go ahead, Nigel.
No. What I was going to say, however, insofar as misconduct in public office is concerned, that is not unprecedented. People have been charged with misconduct in public office. So there are places where people, but the circumstances are a lot different.
Misconduct in public office as it relates to elections?
Misconduct, that's an interesting one. Good question. I'd have to come back to you on that. I know misconduct in public order, but specifically for elections, no, not that I'm aware of.
Yeah. I've been trying to see if there is precedence to this kind of thing, and I've not found any. But this thing about defrauding the electorate, what statute does it fall under? Is it a violation of?
No. What they've done here is they have brought the charge on the common law. So conspiracy is a common law offense. You could accuse somebody of conspiring to do anything and say it's common law. So I can accuse Aubrey of conspiring with Vincent to procure a result, and the charge is conspiracy. Defrauding the electorate, technically they will argue that is not the offense per se, because if you're fraud in itself, again, not a common law offense. So you're conspiring, one, common law, to commit a fraud, common law. And they're saying defrauding the electorate. Well, that's part of where the battle is going to be. You have a big debate, as Vincent just pointed out, as to when you say electorate, we're talking legitimate voters, dead voters, voters who were not here. Who is the electorate? And if the list, for example, which is the point Aubrey always makes, if the list, for example, which is quote unquote the electorate, is not a real list, as in a true reflection of the eligible persons who should be on the list, then you're going to have huge arguments as to what electorate, which electorate. They will probably seek to argue, well, the electorate is the list is declared, and who suffered the fraud. So this is going to be a source of a lot of debate going forward.
Nigel, and notwithstanding what Aubrey has said, and I completely agree with Aubrey that there is a political dimension to this. Perhaps the source of all of this is political, and they're hoping the outcome will be political. But I think this is a test of our legal system. In fact, from the time of the no confidence vote to now, I have never seen our legal system come under so much scrutiny, and I'm saying that deliberately because it is. My own view is that the outcome of these cases could set precedents. Do you agree with me?
As a practitioner, we have migrated political problems into the legal system, which is not equipped to deal with it. This is not the forum, from my view, to deal with it. This has been said from the time the first set of private criminal charges were brought. This institution is not equipped to do it. And therefore, I would not say that we should wait for the outcome of legal procedures or legal trials, essentially to address what is essentially a political problem. We have to have, the system has to work. And I fully agree with that. The system has to work, and therefore the legal system cannot abdicate its responsibility to deal with what it's brought to it. As a matter of fact, it's under a lot of pressure to make sure that it delivers or demonstrates that it has the capacity to handle these issues. I wouldn't comment on that at the moment, because we have, I would say, years of legal battles in all of these matters, which will probably go all the way to the CCJ.
Yeah. Let me start with you, Nigel. Is there a problem here with separation of powers? Because you're saying that we are migrating political matters into the legal system, and that's not the case. In my mind, insinuating that those matters are probably for the executive or the legislature. No? Yes?
You see, the legal system cannot refuse to take a complaint, charge, civil suit that is brought to it. It can say early, look, I think your application has no merit, maybe frivolous and vexatious, and strike it out. But it can't decline jurisdiction, so to speak, save and except where it's dealing with processes in the National Assembly, because the National Assembly is responsible for the management of its own affairs. One of the things about the no confidence vote is the question of whether the court could properly have addressed those issues in the way it did. That is going to be debated between scholars for a long time, because that was part of the process of the National Assembly. And the court, of course, went on, heard matters, and made various pronouncements. So to come back to your question, I'm not sure that there's an overreach by the judiciary, because it can't decline to hear matters that are brought before it. The fact that we may be at the preliminary stage may preclude a comment on it. So, for example, these charges that are going to come. Well, let me just give you an example. When the private criminal charges were filed, we heard from the lawyers who were representing those persons that they had 800 witness statements. I just want you to think of 800 people going into a witness box to testify and be cross-examined. This is going to take a decade. And that in and of itself, I think, was an opportunity to the court. The court may say, well, you can call as many witnesses as you want, but 800 witnesses to establish what? So the court in and of itself should have a process in which it weeds out a lot of unnecessary things. If 800 people are coming to say the same thing, you don't need 800 people to come. So that puts a burden on the defense or the accused, because an accused person who hears 800 people are coming to testify against me is naturally going to be intimidated. The people who read that in the press are going to think, my God, this is a burden. The defense counsel, this is going to consume a lot of their time, etc., etc. So, as Aubrey said, a part of this is perhaps intended to intimidate. But to come back to your original question, I'm not sure that the judicial system can decline to hear these matters without first having the evidence before and then taking submissions, preliminary or otherwise, as to whether or not they are in the right forum.
Got you. Vincent, let me get you in here, Vincent. There is a lot of speculation about timeline. And one speculation includes the chairman of the Elections Commission. In fact, Aubrey, last week, I think, on this very show, alluded to it when he asked, why have they not charged for the thing? The speculation is that up to a certain point, she went along with the process, the very process that they're now saying that was tainted and that was reminiscent and of fraud and so on. Can you speak to that? Someone who's part of the action, close to the action? I know you.
The most I would say on the matter is I did not share the view that she was being brought for contempt of court. And there was a particular point in time where she refused to act on condition that she had made a promise to the court and that matter had not been dealt with by the court, and therefore if she acted, she would be in contempt. I did not share that view. So for me, that is where something went awry. She did not comment on what had occurred as to whether it was right or whether it was wrong. She simply refused to act on the grounds that she'd made a promise to the court and that had not been, and that she would be held in contempt if other things occurred. I never understood that, because as I understood it, I never heard the court say to her that you are pronounced on the question of contempt whatsoever. She simply made a promise to the court. My understanding is that subsequent to that promise, when Mr. Mingo went to High Street, what was displayed was statements of Paul. What she had promised is that would be done.
Mhm.
And so she could not be held in contempt if he had acquiesced to what the court suggested should be done. So I really did have a problem with that. And failure to act at that point in time was indeed part of the problem that we were caught up with.
Mhm. Aubrey, is that you? Expand on that passing comment you made. On that passing comment you made in reference to the chairman of the commission. Is that coming from anyhow? Yes, Aubrey. Expand on that passing comment you made. I think it was last week you were on this program in reference to the chairperson.
Go that again. I didn't get you.
No, last week on the program, on this program, you made a passing comment that they're charging the chief election officer while they're not charging the chairman of the commission.
What I said the last time, it appeared to me that the chairman of the election commission was dealing with the chief elections officer and everybody going through the process. And it is only after, I think, around the 13th or 14th of March, somewhere around there, that there seem to have been differences. My point is, if during this process at Ashman's, etc., she was, as they suggested, part and parcel of what was happening, because don't forget how they behave and went on about her. Janu at one stage, where I assume by that time it appears as though some deal was struck, start to say to them, go quiet on Claudette Singh. But before that, they were going on and establishing that she was into all kinds of things.
Yeah.
My position, therefore, was that if they were going to charge for anything happening in that particular period, then as a logical sequence, she should have been. But let me go a little deeper than that. I don't remember if it is Nigel who said that it's a test of our legal system.
It was me.
I think politically, the legal system has been tested and failed. And I'm here separating criminal matters from these political matters. Let's go back. One assumes that the DPP is a professional who operates independent of political instructions. And so a file was prepared in which Irfan Ali had 19 charges. Anil Nandalal was charged for law books. And the DPP says, go ahead, there is enough of a case. You remember that?
Yes, yes.
So here is a person who is supposed to be operating independent of the political machinery, saying charge them. But the minute the government changed, these charges were dropped. There are only one or two things, a few things that could happen here. One, at the time when she suggested the charges, it was wrong. And if that is the case, there are problems. Two, that when she suggested that they be dropped, she was now concluding that they really didn't have a case against them. Now, that puts her in a position where obviously you can't claim independence and operating as a professional. And then we heard throughout our lives that these matters are investigated, sent to the DPP, and the DPP will determine whether there are charges or not. Not so these cases. Not so these cases. And so one sees not an attempt to ensure justice and the independence of these legal institutions. What one sees is the intrusion of politics to persecute so you can prosecute. And so the answer to that question is that in political terms, it is evident that the office, the DPP office, is not operating as a professional institution dealing with law. It is operating as an appendage to the political system. And so one no longer can talk about independence and the law. The assumption that is made when the DPP is given the power to withdraw charges or institute charges is that the person holding that office will be guided by law. Now, the same charges that were brought against those from the PPP who private criminal charges were brought against, and Claudette Singh, how do you explain withdrawing those from Claudette Singh but leaving them on the field? And then you turn around and take it over. So the point I am making here, at least when it comes to political issue, our judicial system, our legal system is compromised. And one cannot respect a DPP that doesn't operate based on law. And having been to university, sat in the same class, it worries me that we have moved from a point where we could have relied on a DPP to look at the law and operate based on the law to a point where it is clear political direction determining more than the law. And that is a big worry. And I say to people who are PPP, who are sympathetic to the PPP, it should worry you, because the time may come in other cases where the law should be stuck to and a political directive can be given and the law is not followed. So one of the downsides of this entire process is clearly the compromising of the legal system to the point where there can be persecution politically and then prosecution legally, though it is illegal. And so that is a worry I believe all Guyanese should have, because the system was intended to have an impartial DPP. Then we come now to the police. The law is clear that the political directorate should give general direction to the police. But we had a situation where it was alleged that the minister that didn't know the difference between battalion and battalion, or called battalion battalion, went in and was trying to direct what the police does. If you're in a situation where you remove from giving general guidance to the police to actually directing the CID what to do. We are ending up where we were pre-2015. And it is the same reason for which we had a lot of unsolved murders, because the police was handicapped. And when those murders, etc., had links to the PPP, they couldn't act. And so we ended up with a lot of unsolved murders. And so there should be a general concern that the legal system is being perverted and we are on dangerous grounds.
David, I don't know if you would permit me through
Yes,
you.
yes, I was coming to you. Go
Aubrey,
right ahead.
No, to ask Aubrey a question.
Yeah.
We know that you can't statutorily provide for integrity. The society clearly has a problem here. So I don't think we can rely on the integrity, etc., because we've had this problem reoccurring. So my question to you, Aubrey, is from a structural point of view in the society, what it is that we do to establish a system that is not as dependent either on an individual or on this amorphous entity called integrity, but is robust enough to at least deliver what you expect from those offices. Because as you know, throughout the history, we've always had a lot of cases where matters have come down to personal integrity and people have different views. So just from a structural point of view, what would you advocate be done?
Structurally, I think a position like the DPP should be determined by at least 2/3 of the parliament.
But therefore you're throwing it back to the political. So you still think it should be headed by an individual as opposed to a broader body that makes those decisions?
There is one that is one option. It can also be a body of more than one person. But the problem we have when it is a body of more than one person and you're dealing with a corrupt regime like this, the resources are always there to bribe everybody. I mean, we're seeing in the system that if you end up with 3 judges that are pro-PPP, you haven't solved the problem. We have a difficulty. Let me tell you what it is. We have a bad political culture. A political culture that is aimed at domination and control. We have little or no scope for compromise and consensus. And so, in large measure, concepts like civil society no longer apply to us. I believe that we have to have changes in the political culture before we can go anywhere. We are a small society. Whoever we appoint as DPP can be influenced one way or the other. If you put 3 of them, what I think should be done too is declare mechanisms to review these matters. DP should not give the authority for that person alone to decide. There should be some counterbalancing mechanism where she has to go either before a tribunal and rationalize the position rather than by the very stroke of a pen. You could decide who gets charged and who don't get charged. And so I am not sure I have the solutions to it systemically. What I know is that there is need for a system to remove the individual bias from it.
And I suppose that is what, Nigel, I'm going to throw that question right back to you and Vincent. What can be done? Because go ahead, Nigel.
I will defer to Vincent on this, and then I'll come back.
Vincent. Vincent is gone? Well, Nigel, okay. Vincent is gone, so you'll have to go.
so I can't hide. Okay. The structure, I start off from the premise that we live in a divided society. I don't think Aubrey doubts that. My difference with Aubrey is the amount of time that will take to change our culture, not only from the perspective of leadership on both sides at the same time and their willingness to change the culture. I don't see that happening. So for me, I assume that we divided. I assume we will continue to be divided. And therefore, if we are divided and we have a legal system that vests power to institute something as serious as a criminal charge, the system must ensure, at least as far as possible, that you exclude the possibility of personal bias. Now, the question with that is, how is that structured? I agree. A 2/3 or a supermajority in the National Assembly in a divided society is probably as good as you will get to identifying people who enjoy the confidence of both sides. So that is a significant position. But having said that, we have the experience of the appointment of the Chancellor and the Chief Justice, which when we made the amendment, it said that it had to be with the concurrence of the leader of the opposition. And the problem with that is this: in a normal functioning society, if I propose Vincent as Chancellor, and the other side says, no, I have a problem with Vincent, I'm assuming those problems would be articulated privately, but it would be good, valid grounds. But the second I seem to have a vested interest in Vincent alone and nobody else, then it does two things. It puts Vincent in a difficult position, because if I only want him and no other possible person, then it says a lot about what I expect of Vincent, and Vincent may perceive that to be what I expect of him. So I think we have to have a system that works. I like the 2/3 for the appointment of the Director of Public Prosecutions, but I also think that there needs to be a committee is not the word, but whatever, a body of 5 extremely experienced persons in that specific field who will act either as a filter or a review body for the decisions that are taken. Because that's the only way you're going to have two sides in a divided society. I hear the story about changing our culture, but it ain't happening in my lifetime. And therefore, we have, for me, I start from the basis that we will be divided for a long time. So what it is that we can put in place in terms of institutions that will at least guarantee the quality, the minimum level of fairness, and the minimum level of equity that will insulate the decision-making from individual individual discretion, individual bias, etc., etc. But this is by no means a comprehensive study on it. But that's where I think I depart from Aubrey. I agree the culture has to change, absolutely, ideally, but I don't see that happening for just now.
But if the institutions themselves were to undergo some kind of change, that in itself would influence the change in the culture. So I see it as a two-way thing, and I like the idea of a review body. In terms, comment on this issue of institutionally dealing with an office like the DPP. Should all of that power be left to the discretion of one person?
I think there should be controls. So, for example, yes, the DPP may have the right to institute charges. On the matter of private charges being brought, withdrawal should be with reason, and there should be some forum to which the person bringing the private charges could appeal if the DPP decides to withdraw those private charges. Circumstances like the one where where charges are brought by the DPP and they're then subsequently withdrawn, then it has to be with reason, and there should be some mechanism of appeal or review of that such decision. So I think that there should be more controls in place. And I do not in that regard exclude the need for us to move in the direction of special majorities in Parliament for the determination of the appointment of certain officers.
Nigel, let me come back to you. When the government came to power and the DPP promptly withdrew the charges against the president, those charges, whatever they were, against the president, I remember Elder Kwayana raised the point about whether she had overreached. Can the DPP overreach? Your volume. Your volume.
Sorry, on me. Yeah,
Yes,
David, you're missing a very important development.
Okay.
The Court of Appeal in the Brassington and Ashley Singh matter, when they went all the way to the Court of Appeal to challenge whether or not these charges were valid, after the government changed in 2020, the Court of Appeal said to the state, there is enough evidence for the charges to continue. So this is not the Director of Public Prosecutions. This is the Court of Appeal saying that there was no basis upon which we think these charges should be stopped. And this they should be continued because the hearing was either about to start or had gone a significant way. And I think in a society, if your Court of Appeal makes that observation, you would have to have exceedingly compelling reasons why you would then go and withdraw the charges and not raise a reasonable suspicion that your motives are less than sanguine. Because you got your second highest court saying, look, there's enough evidence to go ahead. So I think from the time the court said that, it ought properly to have constrained the scope of activity, certainly in terms of withdrawing the charges, because then it looks a certain way. It brings the entire legal system into further disrepute. Because what would be the basis of a withdrawal of the charges or the discontinuance of the charges, where the Court of Appeal says, hey, there's enough evidence to go forward. So that's important. So it's not just the fact that the DPP had recommended charges and then the government changed and withdrew them. Here you actually had a pretty important step, which is that the Court of Appeal said, look, there's more than enough evidence there. We think this trial should continue, and then shortly afterwards, it is dismissed. It is withdrawn. Sorry.
Is that not a basis for judicial review? I mean, where you have the Court of Appeal saying one thing, and then the DPP, in a sense, disregarding the ruling from the court.
Well, the court didn't say what the court said was that there was enough evidence to continue.
To continue, okay.
Yeah, but you are correct. That decision would perhaps be susceptible to a challenge on the basis upon which the decision was exercised. And it's only on the basis of more and more challenges that this happens. But the legal system right now, and the limited number of lawyers we have, it's not everything that we can go forward with. But it certainly would have been one of the areas, I think, that would have been justified in challenging.
As we wind down the program, Nigel, what's the way forward as far as the charges against the Gecom people are concerned? One question I have, I noticed they've charged the 3 people, but they've not charged the others that they claim they conspired with.
Don't say that too quickly. I anticipate that next week we're going to get more charges against Miss Lawrence. We're going to get charges against Miss Joseph and Miss February and the rest of them, because they have specifically said that the conspiracy involved them. So logically, I would imagine that there will be new charges. I think they did this because these are Gecom officials. And so they wanted to demonstrate at the political level that stuff was being done. But I anticipate that there will be a raft of new charges against Ms. Lawrence, Ms. Joseph, Ms. February, and all the other people who are at least identified in the particulars of the charge.
Vincent, you are the Gecom man here. Where does this all leave Gecom? How does this affect the work of Gecom?
Well, Gecom has been, and I've said it repeatedly so far, has been comatose. It has been comatose largely because of the nature of its composition and the fact that commissioners are outreach officers of the political system. And the extent to which it is clear what is desired by certain people is the extent to which the Gecom commissioners have been a party to executing the plot. So Gecom is comatose. There's nothing happening in Gecom right now in terms of what Gecom is supposed to be doing. Gecom has become embroiled in a very indirect way in all that's happening politically and has not been allowed to work.
Is there or should there be some relationship between the charges that are being brought and the motion to remove the three persons from Gecom? Is
Well,
there a
for me,
relationship?
there are issues involved here. The motion repeats the accusations that are supposedly being made in the charges as well. So it shows that there is a clear relationship between the actors. And the actors who, in the first instance, brought the private criminal charges, because those are the only actors we know who really brought charges, and the Gecom commissioners who have brought the motion. So there's a clear collaboration going on between the Gecom personnel and the political personnel in these acts against the Gecom officials. Clear
Aubrey,
collaboration.
Aubrey, you are the one here that is actively involved in political decision making. You've made the case very passionately here tonight that the legal system is being used as a medium of political persecution. Um, as the politician here, what political action are you all going to take? The audience is asking those questions. Everyone has been asking those questions. If these people are bent on political destruction of the supporters of the opposition, what is the opposition? What does the opposition intend to do politically beyond what you've been doing?
I don't purport to speak on behalf of the opposition here.
Okay.
I can give you my views.
Good,
And
sure.
I'll give you details. In my view, I repeat, they have to be organized extra parliamentary political activities aimed at putting the PPP in check. Look, not what all the noise the PPP making. Soon as people turn up against them in a particular way, half of them just run away. That's all I would say.
And you repeat that view that you expressed here last week on this program. Michael, you have the last word because you are the busy man representing all these people who are being both persecuted and prosecuted. Anything for the audience?
David, like I said, the forum where these people are charged is not the forum to deal with a political problem. We're trying to solve a political problem in the courts, not the place to solve it. As a matter of fact, it is the worst place because you've put people's lives in jeopardy. You put their liberty in jeopardy. You're putting their financial existence in jeopardy to solve or settle political issues. This is not the place. What happens is it hardens positions. It is difficult for people to reconcile from hardened positions. And where you threaten people's livelihood, threaten people's liberty, charge them, where some people believe that your charges are driven by motives other than the evidence that is before you, we're in a difficult place. So we will battle through the legal sphere, but this is a very narrow area. The real problem here, which has not been addressed and which has never been addressed, is the political issue.
Yeah, Nigeria can't leave without asking you what maybe is an academic question. and so I'm putting on my academic hat here. What happens when a legal system is burdened with what we talk about there? What happens? What happens to that system in the aftermath of the burdening of that system to solve political problems?
Well, you see, it comes back to what happens politically, because if you have an aftermath politically, the legal system really will be secondary. And I rather suspect that things we will reach a head politically or in the political environment long before we get to a result of the legal issues, because that's just the history of our country. I just believe that that's going to happen. But the short answer to your question is, if the legal system is overburdened, it will collapse. But I think long before you get there, you'll have a political collapse.
Well, I'm looking for the right word. Ominous, maybe. Profound, certainly. Brothers, thank you all very much for coming on and again helping our citizens and others to really understand and put in context what is happening. Because I do believe that part of the solution to the overall problems in the country has to do with Aubrey hinted at it when he talked about the change in the political culture, but it has to do with a kind of re-socialization of our people, the ordinary people. And I think that what these last couple of years have done is it has brought the ordinary citizen a little more into the political process and the legal process and understanding the linkage and linkages between and among the various branches of government. I think what we try to do on programs like these is to enhance that process. The old adage that an informed citizenry really is essential to this democracy, real democracy that we're talking about. And I'm being modest when I say that I think tonight we've contributed to that process. That what may have been complex issues, we have tried on this program with your help to help our citizens really get a grip of it. And to you, the audience, thank you so much for staying with us and for showing the kind of interest that citizens must continue to show if we are going to really establish true freedom and true democracy in our society. The weekend is coming up. Have yourselves a great weekend. On Sunday, I'll be moderating a forum on the gas to shore pipeline. Sunday the 13th is the 41st anniversary of the assassination of Dr. Walter Rodney, and the WPA wants to use that occasion to talk about a topical issue, and that is the gas to shore pipeline questions and answers. Professor Clive Thomas and the former Minister of Public Infrastructure, David Patterson, will be my guests. It will be an interesting and, as usual, informative discussion. So please join us on Sunday at 6 o'clock for that discussion on the gas to shore pipeline questions and answers. Until then, thank you very much for staying with me.